30 minutes.
Much obliged, Mr. Vice President. Mr. Vice President, I was at the point where I was saying that the current bill caters for a tribunal assessing whether or not to grant bail to disabuse their minds for convictions 10 years and older. And it would be incongruous if that is taken out, and in the proposed bill, that is not something a tribunal can take into account, so that whatever the age of the conviction, it can be taken into account. But what you could have is that very same tribunal in a sentencing forum not taking convictions 10 years and older into account. Now, why that is important for our legal system is that we do not have, like the United States and the UK, where just by the mere fluxion of time, you have convictions expunged from your record. The only place where that is recognized is in the courts. And the practice is if it's 10 years and older, they don't recognize it. So you have persons in our system who have convictions from 1901, simple possession that cannot ever come off their record. It's a stain that follows them throughout their lifetime, save and except if they are fortunate enough to get a presidential pardon. There are, Mr. Vice President, when one looks at the schedule at Part 2, it may be that persons who were not necessarily meant to be captured in this proposed bill may very well find themselves having their liberty detained by design. And why I say that, the best example of that is in the Dangerous Drugs Act. Simple possession is an indictable offense. On indictment, the sentence must not exceed 10 years, but must be more than 5 years. So it falls to be considered within the proposed bill. Now, while it is not customary, or it's certainly not common for persons with a joint of marijuana, upon a recommendation being made to ask for a judge and jury, it does occur. And I've seen it occur, and I've represented such persons. And on both occasions that I did, they inevitably weren't represented downstairs and felt that a judge and jury trial for a joint of marijuana was the way to go. Now, the point is this. If it is laid indictably, and there's no recommendation from the prosecution, then that person can't get bail for the joint of marijuana. Can't. Because the only way you can bring it as a summary trial is if a recommendation is made and you want to have the matter heard in the magistrate's court. Then you fall out of the 10 years and you will be eligible for bail. So there can be very well a scenario where someone who is known to the police find themselves not on a gun charge, on a simple marijuana possession charge, and the police don't make a recommendation as they would normally do. There would be nothing wrong with that. There would be nothing wrong with that. And there you can keep Mr. X, who you know to be notorious, and you can keep him for 120 days. There will be this scenario, of course, where persons are unrepresented, and they figure the way they'd rather have a judge and jury, and they cannot be given bail. And I don't think that the bill intends to capture such persons, but because these offenses are all laid indictably to go to the High Court, and only on recommendation, and if that recommendation is taken, that you could fall under the 10 years, then it might be an unintended event. So it may be something that the Honorable AG can look at. because certainly we are at a position where the discussion of decriminalization is rife, so that for someone to spend time because they can't get bail for a stick of marijuana, for which if they had pleaded guilty, they probably just would have gotten a fine, depending, of course, if their antecedents are not long like a grocery list. Now, Mr. Vice President, looking at the proposed bill again, I've already said that with regards to Section 5, subsection 3, I would want to put in, just as it is in 5.3b, that while you're charged for a firearm, that alone does not prohibit you from getting bail, but that person should also have at least a pending charge. And the reason is this: because if you're innocently caught up once, and the police pick up everybody in the house or everybody in the car, it is unlikely that lightning will strike twice, not impossible, but unlikely you would find yourself in that situation twice. So a person who has a pending charge is more likely to be a person who has a propensity to be engaging in some type of criminal activity, simply because he is before the court on more than one occasion. When I look at subsection 3C, I must confess that I too have a problem, and I think Senator Hussain did indicate that he too had a problem with this, that where the prosecution informs the court that the person or any other person involved in the commission of the offense used or had in his possession a firearm, then just because of that utterance from the prosecutor, this entitles the person to bail. Now, how it would work is the prosecutor would be telling that to the court. The prosecutor no doubt heard it from the complainant. The complainant no doubt would have heard it from one of the potential witnesses. And once the court hears it, without making an inquiry and testing the veracity of the assertion, or making an inquiry, the court is bound to follow the law and not grant bail. And lo and behold, when the trial comes, there might not have been anything about a firearm, because there were so many, the Chinese whisper how it went, it changed and morphed into something when it was uttered to the court. But I could see a scenario where, for instance, notwithstanding that you do not have a firearm, let's say there's a robbery, someone was shot, so that you know circumstantially from the evidence available a firearm was used. And perhaps with that type of evidence being disclosed to the court in a real way, medicals and so forth, which match up with the time and date and event that it happened, well then perhaps it could be considered in that light. But it has to be a little more than the prosecutor simply just saying a firearm was used. Now, wherever it appears in terms of when bail is allowed, why is it necessary for the application to be made before a judge? These are matters which currently are before a magistrate. And because the matter is live and coming up before the magistrate, I think the magistrate will be the appropriate person to make an application for bail. That is where it's usually made in first instance, and only upon refusal does the magistrate say that you can apply to a judge in chambers. So if by just the effluxion of the 120 days passing, I see no need why you would need to go to a judge in chambers as opposed to the very forum for which the matter is being heard. I find 120 days too long. So notwithstanding all my difficulties, which I've indicated, 120 days I find a bit long, and perhaps that could be considered 60, 90 on the outer end, still kind of high. But it all must mean that something can happen within that time. I've already expressed my reservations with respect to being able to obtain the forensic certificates of analysis in that time, but perhaps statements can be filed and other things can be done to begin the process towards starting the trial in a short time. I am of the view, Mr. Vice President, in any event, where the defense is one of denial, it really doesn't matter to me if the forensic comes back and says the gun is a gun. I deny it in any event. Whatever it turns out to be, I deny it. And in those circumstances, we should have legislation which kind of caters for that scenario. If you say it's drugs, whether it's drugs or not, it doesn't matter to me, because I am saying I did not have it. So all the years it taken in the forensics, really of no moment. Mr. Vice President, I'm certainly bypassing all my points which were traversed already by those who went before me. When I look at subsection 7, which says, for the purpose of this section, except subsection 3A, where a person is charged with an offense listed in Part 2 of the first schedule, and evidence has been taken within 120 days of the reading of the charge, but the trial is not completed within 1 year from the date of the reading of the charge, that person is entitled to make an application to a judge for bail. Same thing applies. Rather than a judge, could be the magistrate from which you are appearing. The other problem I have with this, Mr. Vice President, is while the accused man is counting down his days to reach the 120-day mark and oscillating between hope and despair, the hope that it's coming up and the despair when he comes to court and still nothing is happening, the prosecution, it's very easy to make a matter parted, because all you could do, say you're ready, submit a statement under the paper committed provisions, and your matter is parted. What that does, it means that when his 120 days comes up, he's not entitled to bail, because his matter started, but not started in a real way, because it started and it has to get an adjournment for this to happen and for that to happen. But technically speaking, it has started, and the prosecution would be right to make an objection to bail. And so he has to stay there for a year. And I have a difficulty with that, because the system opens itself up to be manipulated, but manipulated in a way in which it caters for that. I can start the matter. I can file my statement. I can read it out and tender it. I have problems going along the way with following it up. And so that I think that has to be addressed, because what you would have is someone who, let's just say it goes in as is, someone who has been charged for the very first time, languishing in a jail for a year. Now, as inconceivable as that may be, that's the possibilities when you look at how the bill is presented. And I'm saying that we must find mechanisms to safeguard against that. Because much is being asked. So we must exhaust all our efforts in trying to make sure that what you propose does the least amount of damage. I quite rather like the change in the specified offenses and taking out those offenses which really were not the egregious type offenses which is in the current act. And I think that is that has to stay. Let me close out, Mr. Vice President, by saying, while I recognize that efforts have to be made, not just by the movers of this bill, but all around, though I have a vested interest in this particular area of law, criminal law, I still try to remain objective from the bench from which I speak. And while in its present form, I have indicated that I have certain difficulties digesting this, I am not saying that it cannot be salvaged. But in its current form, for me personally, it's hard to digest. Yes.
Thank you, Honourable Senator, for giving way. I'm deeply appreciative of the opportunity to intervene. Secondly, I'm intervening because as a temporary independent senator, we never quite know how the vagaries of appointments rule, and I'm particularly intrigued by your submissions. Could I ask if you could directly answer if your concerns would be addressed in the fashion that you've identified, which, as I've caught it, involves a look at the timeframes as may be necessary, a particular caveat to the incarceration for certain offenses, and if you could clarify lastly your main concern as to where you see an abuse could happen. I caught it that you are also inviting that any court may consider the application, not necessarily the formula we used from 2011 to 2015, which was that the judge would consider it. Would you mind lending me your thoughts on those?
Yes, certainly. So let me say that the most pressing concern of all is that subsection 3. And just to, my problem with it is that, and Senator Choate would have touched on it, our law as it is with respect to firearms and dangerous drugs deems you to be in possession. And the police, they have not advanced with the case law. So in the old type cases, Ramdani cases, run-of-the-mill, everybody goes down. Later set of cases, Lakshmi Bharat and those sorts of cases say that if your presence there, it's nothing more than mere presence. You have made no utterance. The particular item is not in a place that you in front of you, then you ought not to be charged. If the police were moving like that, but they're not. So because I'm on the ground, I can say they're still being taken down in droves, and inevitably they get off. Hence, I have a problem where you're bringing this person first time. Could be a student, a professional, anyone, but first time before the court for anything, they're going to jail for 120 days. I am saying, even if you were to bring it down and taper, person who is charged and has a pending, you are likely to take that person away because it's highly unlikely that they would have found themselves in that situation twice. Just saying. Hard, not impossible, but hardly unlikely. You do not have as presently obtains, which I think perhaps from that 3 convictions, it doesn't capture enough of persons in there, because persons who the police may have their eyes on, even though they may have been charged, may have successfully evaded convictions. But they may have pending matters. So I'm saying that if you can make a compromise there, it makes it more palatable. Still a little concern, but more palatable. So that you have here at B, listed in Part 2 of the first schedule, and has a pending charge. Now, when you look at that, Honorable AG, Mr. Vice President, you know what is a common charge? Wounding, causing grievous bodily harm. I have done a number of those at the High Court. Even though it is more than 10 years, you'll be surprised to know that the sentence, certainly in cases that I have done, they're non-custodial sentences. Because invariably, they involve family members. By the time it gets up to court, it's years old, they have made amends, and that person is before the High Court years later, 10, 15, in some cases, 20 years later. Brother, sister, brother, uncle, father, son. A lot of that captured on grievous bodily harm under Section 12. Sorry? Yes, well, okay. Well, one conviction, another charge. Another charge. You see, and so that's it. So, for instance, I've had it again, and person, one conviction up to now. Other one he got off, on trial. But I'm saying, even if we say that that's the lesser likelihood, I'm saying that it is nothing to bring subsection 3 in line with that. That's one of my suggestions. I was also looking at the other concern is that persons who you may not intend to capture, simple possession, these offenses are laid indictably. An accused man has no say as to how his trial goes because they're laid indictably. There must be a recommendation. Only when a recommendation is made, the accused man has a say as to where he goes. If he goes summary, this doesn't apply. I have had the experience where unrepresented persons figure that their chances are better before a judge and jury, not having the benefit of being told that your sentence is greater up there. If he does that, can't get bail, 120 days. If the prosecutor, and this is it, they would be well entitled on who is the accused to say, notwithstanding, it's just. Yes.
So would an amelioration happen if we narrow the pot even further? Because we're talking charge. You're on a charge and you come back for a charge.
Yes.
For firearms, yes, charge. For specified offenses, conviction charge, or charge. So even though it might be slim, that you're really innocent, but you happen to come on 2 separate occasions for the same charge, or a combination of listed schedules, would it be improved if it were 3 charges?
Yes, well, not necessarily. For the particular, what I was pointing out to you is that I don't think you intended here to capture an offense which really does not go indictable normally, because no one who is advised properly
I got you.
goes to the High Court for a joint. But you know, I've experienced it. But what I'm saying is, because persons are unrepresented, which is and they in their own mind think that I want to go before a judge and jury, they don't know by saying that it's 120 days they've signed up for. So I'm just saying that it might be, because the Dangerous Drugs Act is specifically put into the schedule, it's not necessarily that you want the simple possession to be there, but a circumstance can happen where, notwithstanding these persons are unintended to be captured here, they can. As I say, in my experience over the years, it's only 2 or 3 such cases that I know of. Now, the other point I was saying with respect to It was simply with respect to 7, subsection 7, where it is a person who, and I'm going on the basis that as the bill as framed has gone through, a person who has never been in court before, found himself charged for a firearm, is incarcerated. 120 days approaching, but prosecution says we're ready. And it's easy to make a matter part heard. So that part where you say, evidence has been taken, it's easy to satisfy that query to start the case. But my experience is, and I know that stakeholders, much obliged, Mr. President, stakeholders are trying to change it. We're trying to change the way cases flow in the magistrate's court. Right now, it takes years. It takes years. What we're trying to do now is to have it done within days. Some magistrates are blocking off days. It still has teething problems, and I'm saying in those circumstances, you don't make it to the 120 simply because you think you're getting a start. Only for your matter to go on beyond a year. And after the 120 days start, that's it. You're not entitled until the whole year passes, and your case is still going on. So that is something that I think collectively put our heads together, and we can certainly try to fix. Mr. Vice President, those are the extent of my submission. That is the extent of my contribution.
Senator Obika.
Thank you very much, Madam President, Mr. Vice President. As I stand to contribute to this bill. Now, in effect, we have many issues at play, Mr. Vice President. We have many issues at play. Many issues were ventilated, and I wish to sharpen my focus regarding separation of powers and the other areas where this bill tramples on the liberty of persons. But I want to start with the Constitution, Mr. Vice President, because I listened attentively and I heard Senator Simonet stated that bail is not a right afforded to one who's a citizen of Trinidad and Tobago by the Constitution. I'm not sure if Senator Simonet represented the Constitution well. One may say misrepresented. I would not use such strong terms. But the Minister of National Security tried to cover for Senator Simonet when he pointed to Section 5 of the Constitution, and specifically 5, subsection 2F, where it states regarding the provision of the rights of a person in terms of liberty and the right to responsible bail without just cause. Reasonable bail, without just cause. Now, if one were to take that statement, that one has the right to reasonable bail without just cause, then we would have hoped to glean from the Minister of National Security's presentation that there is just cause, as he attempted to shift the debate to focus on just cause. And I'm saying that an attempt to shift the debate to focus on just cause and trumpeting the good work of our men and women in the Trinidad and Tobago Police Service is also a distraction. Because the real issue of this bill, Mr. Vice President, has to do with separation of powers and the ability to deprive one of one's liberty, and where that tramples upon the rights in the Constitution, and may definitely open up the government to litigation once this bill passes, even if it succeeds with a 3/5 majority. So, the Minister of National Security made a case for the issue that he may have with the judiciary, in terms of persons going and they just come out just like that and they get bail. All right? And it appears to an observer as if the intent was to circumvent the judiciary with this bill. And by so doing, circumventing the rule of law and, of course, trampling on the rights of citizens with no just cause, contrary to the assertion of the Minister of National Security. And I want to reference what the minister said, because the minister referred to persons who are being denied bail as criminals. Now, one always asks the question, in all these bills that we are bringing here, and the terminology that we are using, warehousing of persons, and he referred to persons as imps and so on, is it that the Minister of National Security is saying that there is no presumption of innocence until proven guilty? I listened to Senator Heath, and Senator Heath indicated, and he stated very clearly, Mr. Vice President, that persons in remand are innocent. He did not say they are pests. He did not call them criminals. They are simply on remand, and they are innocent. I wouldn't even need to add the until otherwise, because that is understood. You are innocent. So if one is innocent, you need to treat them with the respect and keep, in terms of preserving their rights as citizens of Trinidad and Tobago. Now, and of course, if one is incarcerated, the only right that you must surrender is your liberty, freedom of movement. Now, Mr. Vice President, the minister talked about, Minister of National Security spoke about supporting the law and that the police is asking for this. And they read into the record a press statement by the Commissioner of Police. But the police also apparently called for the anti-gang bill. And it shocks me to see that the minister said that he meets weekly, on a weekly basis, every week, with the heads of national security apparatus in Trinidad and Tobago. Every week. The year has passed already 23 weeks. And he can only boast of just about 5 charges, not one single conviction. Now, Mr. Vice President, if that is the standard that we have to aspire to by relying on a press release from the Trinidad and Tobago Police Service and saying that because they are merely calling for this, that we must deny citizens their rights, and the only thing he can hold up is 5 charges. Charges are dime a dozen. Charges are dime a dozen, especially when the Attorney General came to this Parliament, Mr. Vice President, and said that there are hundreds of gang members. We know their names. Yeah. We know their addresses. Yeah. We know where they lie. We know their crew. We have the gang here, the gang in this town, the gang in that town. And after all of that song and dance, 5 charges, Mr. Vice President, we cannot be serious here. If we are to now rely on another press release from the Trinidad and Tobago Police Service, and the standard that we are aspiring to is after 23 weeks, 5 charges. I will leave that there. Now, the Honorable Attorney General, in his presentation in piloting the bill, pointed to the rise in murders and connected that to migrant issues. He tried to cover by saying it's not only Venezuelans. However, the Commissioner of Police already sounded a warning when he indicated he had some challenges with the amount of criminals that are coming in. When he said criminals are coming in with persons from Venezuela, they are not all persons coming here as economic migrants. Some of them are connected to crime gangs at an international level, the kinds we are not accustomed to in Trinidad and Tobago. And a criminologist, Darius Figuera, in an interview covered in an article titled, "Criminologist Warns, Venezuelan Violence Will Spur Crime Wave" by Shaliza Asinali on Friday, April 12, 2019, which appeared in the Trinidad Guardian newspaper. He stated, and I quote, "Last year, he said the government in Guyana had to move in additional troops to its western border with Venezuela to deal with heavily armed Venezuelan gangs crossing the border as they created havoc and lawlessness. He said TNT could end up like Guyana unquote, Mr. Vice President. Now, I am one for Caribbean unity. And the Cooperative Republic of Guyana is our Caribbean sister nation. With pride, I say that. However, if they are suffering these challenges, do we want to follow them? And I continue with this quote on the article. Closing the gate now is irrelevant, he said, referring to the government's move to register all illegal and legal Venezuelans living here. The government do not want to accept the price we will pay for having them flocking into our country. They don't want to understand the level of criminality that exists among them. They now have a foothold here, and they are not going to give it away. These criminals are going to change the nature of violence in this country. The police will have a hard time on their hands as a Venezuelan crime wave has been launched, Figueroa said. And of course, in that same article, the Commissioner of Police, Gary Griffith, said he was cautious about the amnesty the state has offered to Venezuelan nationals. Now, there are 3 points that arise to my mind from these statements by noted and renowned national criminologist Darius Figueroa. Number 1, the government is burying their heads in the sand regarding the issue of Venezuelan criminal gangs connected to South American crime syndicates, and is a problem of their creation. Why is that? We will see in my presentation. The second issue is the Commissioner of Police is at odds with the Minister of National Security on this same issue. And the third is that the government, and by extension the people of Trinidad and Tobago, are watching on as hapless spectators as crime runs out of control. Now, Mr. Vice President, Clause 5 of the bill. I don't want to commit the same faux pas as the last time, so I want to make sure I'm on the right page. Mr. Vice President. So Clause 5 of the bill, and this would be on page, the relevant section will be on page 3. Mr. Vice President, the bill is excessive. The contemplation of 120 days is excessive. I listened to Senator Heath when he was trying to look at what would be an outer ring, 60 days, 90 days, 40 days, 30 days. But do you know, in many professions, many occupations, if you do not show up for work after 5 days, they most likely would take you off the register, notwithstanding the best efforts of your trade union representative. Abandonment of work. And you know why, Mr. Vice President? Do you think you would want your employer to know that you are not in work because you are in remand yard? No. You would not want that to be the result. You would hope that you could get away with a medical certificate. All right? So there are many persons who were picked up by the police and were threatened with abandonment of work, only to reappear just before the ink dries on the letter for the dismissal. So, and in that case, it's not a dismissal. They have abandoned the job. Yeah. So if you are subjecting a Trinidadian citizen, a national of this country, who is working somewhere, to more than 5 days of detention without bail, you may make that person lose their income, their livelihood. And then, of course, it would point you to the reasons why it may make that person more susceptible to even offend if they were not an offender in the first place, or re-offend if they actually did offend. And why do I say that? Because then there are normal conditions that are contemplated for bail. The Law Association has it clearly: travel restrictions, reporting requirements, residency orders, curfews, and so on. But Also, if you think that the person has the propensity to re-offend, and if you take the salary from someone, you take the food off of the tables of their children, and that person had a propensity in the past to offend, what you are doing, Mr. Vice President, is pushing that person to the only thing they may know, which is crime. So this in itself, by detaining persons for more than 5 days, is a criminal act, and we cannot support it. Now, it's excessive. And I want to read from a judgment, Mr. Vice President, because I couldn't try to be eloquent in my delivery today, but I couldn't commit this part of it to memory. All right, so I hope you can bear with me where this is concerned. And it has to do with the separation of powers and deprivation of liberty. And also a subject that is close to the Attorney General's heart, which is preserving the ability to not have to pay for legal suit. What I'm saying, the denial of bail can open up the government to legal suit, which can cause the state to lose monies. And I wish to make a quotation, just 2 paragraphs, from a judgment, Terence Calix versus the AG of Trinidad and Tobago, the judgment delivered by Lord Kerr on 23rd May 2013 at the Privy Council. Now, and I quote, Privy Council Appeal number 3 of 2012, page 4. In an extempore judgment delivered on 24th November 2010, the Court of Appeal dismissed the appellant's appeal, Solmaya J., delivering the unanimous judgment of the court, said that the trial judge had correctly assessed compensation for the damage to the appellant's reputation in relation to the claim for loss of liberty. He said this, quote, the issue which arises here is whether a person who is incarcerated, although granted bail, can receive a award of damages in malicious prosecution under the head of endangerment of liberty. In the circumstances, I have come to the view that the grant of bail by the magistrate, although not assessed by the applicant, is in law a sufficient ground in this case, to disentitle him to an award under his head. Now, that is the preamble. What I really want to get to are the points that he made. The first point. The first is that granting bail interposes a judicial act between the prosecution and the continued detention of the accused. The prosecution is no longer the cause of the deprivation of liberty. That deprivation is caused by the judicial act, unquote. That's the first point. And what flows from that? The prosecution in this case, where this bill is concerned, will be the cause of the deprivation of liberty of persons who are denied bail, when in fact it should be subject to a judicial act, not executive action. What this bill will do, Mr. Vice President, is endorse executive action, not judicial action, denying persons right to bail. The second point. Actually, that was the main point. So the other issues are, I don't want to read the entire thing into the record. It will take too long. So the other issues regarding this is that the accused persons in this case will have no opportunity to apply to a magistrate or a judge for bail or variation of same. And the state in this regard will be culpable of endangering the rights and the liberty of the accused. Another issue, Mr. Vice President, that I want to ventilate, which flow from this very judgment, has to do with the impact on reputation when bail is denied, and the circumstances that surround the denial of such, which can result in the state having to pay costs, pay damages. And I quote from the very judgment, on his appeal to the board, the appellant contended that the trial judge had engaged in a series of speculative assessments about him, which had led to a plainly erroneous evaluation of the damage to his reputation. That the judge had failed to take sufficiently into account the appellant's good character and the seriousness of the offense on which he had been tried. That he had equated the appellant's lack of social standing with his character. And on that account, wrongly concluded that his reputation did not amount to much. And that in consequence of these errors, he had made an award for loss of reputation that was inordinately low. Now, the issue here is, when we have a Minister of National Security calling persons who are innocent criminals. We have started already on the road to the maladministration of justice in this country. Because when you do that, what you are doing is you are assassinating the character, Mr. Vice President. And you know how culture works. How culture works, especially in a small country like this, you may not be privileged to have a unique culture that is distinct from the rest of the nation. So the culture of how persons may perceive ones who are denied bail, who are incarcerated on remand, the culture will be that since the Minister of National Security, in his wisdom, can see those persons as criminals even though they are innocent, then who am I? The ordinary citizen. They are criminals. So once anyone, there may be an officer, there are many great officers, Mr. Vice President, in my family. My grandfather, my maternal grandfather, retired as a sergeant. My uncle as well. So there are many great, so the blood that flows in my veins is that of an officer of the law of Trinidad and Tobago. So there are many great officers of the law, but to err is human. And we know that they are also, as they are good, they are also corrupted officers. And on an ammunition charge, if you turn to the Firearms Act, on an ammunition charge, I have the verbatim here. Okay, put it in. Please excuse me. Section 6, Part 4, Subsection 4 of the Firearms Act, Chapter 1601. It states, in addition to any other offense for which he may be convicted, a restricted person who purchases, acquires, or has in his possession a firearm or ammunition contrary to Section 1, Subsection 1, is liable in the case of an offense under Subsection 1 on summary conviction to a fine of $75,000 and to imprisonment for 15 years. So how difficult is it for a police officer who is not confined to body cameras, despite the media storm surrounding when it was outdoored, who is not confined to body cameras for anyone in his search party? How difficult is it, Mr. Vice President, for him to simply lodge in your possession some bullets?
Senator, at this juncture, being the 11th speaker, we've heard the issue put forward before by numerous senators in relation to that particular section and how easy it is to frame an individual. So at this juncture, I invite you to bring forth any novel or new points that you may have in relation to the bill that's in front of us.
Thank you, Mr. Vice President. Can you tell me how much time I have left?
Finish at 6:38.
I won't detain us much longer. But there are some points I want to reflect on regarding the statements by the Prime Minister. But before I get there, Mr. Vice President, we had an excellent meeting in San Fernando yesterday. And a brother in the crowd asked me for a copy of the Constitution. And I know it will interest you as to why. Because he's worried that he's losing his rights every week when he sees laws being passed. And he sees the rampant crime scourge in the country. But I duly informed the brother that I always walk with my copy of the Constitution. Just in case, I have to remind members of the government, including Senator Simonet, who may surreptitiously misrepresent the Constitution of Trinidad and Tobago. I wouldn't want him to do that unknowingly. Unknowingly, you know, so I use the wrong word. So I wouldn't want that at all. Now, Mr. Vice President, I want to close on some reflections. In the first 6 days of 2014, from an article, May 25, 2019, PNM's billion-dollar crime bugbear, and Lisa Paul in Trinidad Guardian, it's reported in the first 6 days of 2014, the then opposition leader, now Prime Minister, stated that I can't recall at any time in this country a bloodbath taking place like this in this week, where 16 murders occurred. However, in the month of April 2019, just a few weeks ago, 3.5 years into this government's term in office, it was declared the bloodiest month ever in the history of this country, where 49 persons died in just 30 days. Now, and the government, I want us to reflect on that. And I also want us to reflect on the promises being made. And I want us as a citizenry to juxtapose that with the statements made by the Minister of National Security, as he was a guest in this House. I'm not sure if those statements would hold water if we put it to the test. Because he made many statements in terms of policy, many statements in terms of policy that they intend to achieve. After 4 years, what if you can't achieve after 4 years? I'm sure persons won't be waiting for another year. Now, Mr. Vice President, establishment of a joint border protection agency. They are still blaming the last administration for porous borders. Development of a disaster risk management policy. The flooding in October belies that. Utilizing the citizen security program, they closed that down. Instead, their plan is to lock up and run down youths and call them pests, criminals, and all other derogatory terms so that they can't aspire to any contribution to Trinidad and Tobago. They went on with partnering with the judiciary to re-engineer, and this is the most important one. Partnering with the judiciary to re-engineer the structure and improve the efficiency of the criminal justice system. But we had to be subjected to a presentation, notwithstanding this promise by a Minister of National Security who is saying that they simply can't trust the judiciary. They simply cannot trust the judiciary to take care of business. So no bail. Because every time one fella go in, he come back out. So this flies in the face of the promises that they have made. And the last one is adopting an intelligence-led approach to national security. We could see that the intelligence that led them to Bourgeois Hotel room, what happened out of that. And the last point I want to leave with.
And San Fernando West, so like people, how's the rate?
The last point I want to leave you with, Mr. Vice President, is this. If we look at the murder toll from 2010 to 2018, the murder toll in this decade, the highest rate of murders happened in years when the PNM was in office. 485, 2010. 2011, it dropped to 354, 383, 408, 403. Then 2015, 420. 2016,
Let me
463.
just caution you at this point. There's a bill in front of us that treats with an issue that does fall under the wider topic of crime. But what you're doing right now is actually engaging in a more crime debate as opposed to debate dealing with bail, which is the bill that is before us. And as much as you're indicating that you're wrapping up, I'm going to ask you at this point that if that's what you're doing, to wrap it up, because as you're extending onwards, it's becoming more of a crime debate as opposed to the debate on the bill that's before us.
Thank you, Mr. Vice President. I was simply responding to the issues that the Minister of National Security trumpeted, that they claimed that they would solve, but now are blaming us, blaming the past administration after being in office for 4 years, 4 whole years. So the people of Trinidad and Tobago are not going to buy any argument that the police want this, so we need to have it. We need to trample their rights. Because the same argument was advanced that the police wanted the anti-gang bill. The Minister of National Security is saying that he meets with them every single week. 23 weeks have gone in the year, only 5 charges he could trumpet. So the people are not going to buy their arguments. What the people want, Mr. Vice President, is a government that will take the bull by its horns and solve crime. And they will get that as soon as the election is called and the United National Congress returns the government. I thank you.
Senator Deyalsingh.
Thank you, Mr. Vice President, for giving me the opportunity to present on this bill, the Bail Amendment Bill 2019. In the opening statements by the Attorney General, I gathered 2 things I got from it, actually. One, that the he mentions that, our borders are not being protected. He mentioned that more guns are coming in, machine guns, and a lot of ammunition is here. Also, the migrant population is here. And when he mentioned that, I saw really, it looks like if it was a failure of the executive to reach its mandate. The second thing I noticed from his contribution, his opening contribution, was the fact that, it was like an appeal for help, an appeal for the senators here to see how we can rescue the country from the crime that is taking place, from the guns, and, and this bill is supposed to help against this. So while I'm going to look at this bill, I just want to look at reasons why I am against it and reasons why I'm for it, to make an opinion, to say, hey, this is my final opinion on the matter. So why am I against it? Why would I be against a bill that actually seeks to protect society in a way that it would protect the society from persons with guns, persons who reoffend, from serious crimes? So on one hand, we have a duty to see if we could protect society. On one hand, we have a duty to see if we can somehow give our citizens a little escape, a little buffer from the criminal activities, going a little breathing space. But on the other hand, we have to ensure that the rights of a citizen is not infringed. And, that goes back to, conventional law, our whole idea of, where we looked at the English system, and it actually shows us that in a civil society, the rights of the individual, we have to look at that. We have to guard against the rights of the individual. We have to look at the presumption of innocence. And even the Declaration of Human Rights in 1948, under Article 11, Section 1. That Declaration of Human Rights in 1948 looked at the French Declaration of the Rights of Man and Citizen of 1789. And since then, it stated, every man is presumed innocent until declared guilty. In the French Declaration of the Rights of Man and of the Citizen, decreed by the National Assembly, Article 9 informs, all persons are held innocent until they shall have been declared guilty. If arrest shall be indispensable, all harshness not essential to the securing of the prisoner's person shall be severely repressed by law. Sure. Yeah, sure. Yeah. So what I'm looking at is this declaration since 1798 did in fact give the individual, the presumption of innocence before the law. And if there's a presumption of innocence, therefore, it is expected, naturally, that if I'm innocent before the law and I'm not guilty, the state has to prove I'm guilty, that level of innocence would, somehow give me the level that I am supposed to get bail. I am entitled to that bail. But as I looked at it, we have seen that the granting of bail is not absolute, because there are instances where the judicial arm would look and see if this individual may abscond, or if the level of the crime is such a heinous crime, or in such a way that crime would allow an individual to go back in society and cause harm to society. Those instances, you are able to look at that rights, and even if it's a presumption of innocence, you are still able to hold that individual with the bail. So it's not an absolute right. So therefore, I looked at this reason why I may be hesitant, and I may be hesitant because the presumption of innocence is not there. A second reason why I would be hesitant to support this is, as one of the senators mentioned, I think it was Senator Obika, that we have always been hearing in Parliament, it's only a small amount of criminals, a small, known gang members. We know who are them, we can go after them. So therefore, we pass legislations to support this. So therefore, if we have had other legislation in place, why have not, somehow it made a dent into this level of crime that we have, because we have given the support to the government previously in passing certain bills. Gang laws were passed, and you see, if we have confidence in these laws, we should be able to get results. So this is another reason why I might say, hey, there are other laws in place that can take care of the situation. Third, an abuse of power. And senators have already mentioned that. Senator Vera mentioned about persons being framed, so I wouldn't go in more to that, because we have cases where persons have in fact been framed, and even in the past we had a member of parliament with missiles in his water tank. So we have to be careful of abuse of police power. So this is a third reason I may be a little hesitant. Can we trust the police service? We have a new police commissioner, he's trying, but somehow we have to look at if we give this level, this freedom for police officers to, the prosecutors to go to court and say no bail in certain instances, would they plant a gun? Those are realities that face us. A fourth reason why I may not want to support this is because of the fact that we have overcrowding in prisons. It's a known fact that the prison, the remand yard is overcrowded. And the report that we had from the Joint Select Committee, when they looked at the human rights issue in the prison system, they had mentioned the fact that, if these areas are not addressed, because the JSC on human rights, equality, and diversity spoke about overcrowding in prison. They spoke about mental illness. That report actually shows you the amount of persons, overcrowded conditions. All of those are effects in the prison system that we have to be very careful. If we are going to be putting more persons in that, we may be opening ourselves up for for legal litigation, because people will say, hey, you're going against the human rights. So this is something we have to be very careful if we are not opening the doors up for that. So the overcrowded in prison is something why I'm hesitant also to support this. Fifth reason, I'm thinking there are other laws in place, as some senators mentioned. Is it poor house management? Is it a failure of the state to staff the DPP, to have more things in place, to get the present laws we have, to get it into motion, to operationalize these laws? Remember, we say justice delayed is justice denied. And if you have persons in prisons for a while and you're not putting things in place, we are denying them basic rights. Good. Another reason I would give is the financial strain, because we have already seen some figures that was touted around here, that $50 million a month to maintain 2,235 prisoners. And we have a figure that we got, it's almost 20 to 25,000 a month to keep someone in prison. So these are figures could the country afford a set of prisoners there that the taxpayers will now have to put out money to support. Another reason why I may not support this is the fact that if you have, it was mentioned here, that somehow we are getting the impression that the judicial arm is not functioning as it should. We have gotten that feeling. And if that is so, this legislation is to try to see how could we put mechanism in place to allow, somehow allow the judicial arm to act within a certain scenario where we will have these repeat offenders in prison. So somehow I look at it, is it that we are putting pressure on the judiciary? Is it that the separation of power somehow might be affected? And I looked at this and I wonder, why can't the judiciary in itself have their own internal mechanism to have their own checks and balances to see how, if, there are certain magistrates, certain judges get their act together internally rather than we having to go and tell them, do this. So just as simple, we have three arms: legislative, the executive, and the judiciary. Just to let them be in sync with what's going on and maintain their own independence and have their own levels of functioning and scrutiny in areas like this. Again, another reason I would look at it is if you keep someone in prison, there is a higher chance of being convicted than if they had been assigned bail, as they now take plea bargains just to get out of jail, whether or not they actually committed a crime. So some statistics in America show that. So once you're in prison, you want to get out of jail, you make some plea bargain. You may not even be guilty, but you're doing that to get out of it. And again, Senator Choate actually mentioned that instance where the father told the police officers, just charge him, charge the guy so I can carry this person to the hospital. So we are looking at those reasons, and the final reasons why I am hesitant to support this is our prison officers already overburdened with work. Our prison officers already on the receiving end, they are in a risky job. And with the overcrowding and extra persons in the prison system, you find we are maybe putting our prison officers at risk. And, and he or she may become targets of, of those individuals, where they look at these persons and they become a target for inmate reprisal. So unless we could get our prison system in a way running more efficiently, get more prison officers, improve the conditions of remand yard, these are things I'm looking, unless we get these, I'm hesitant to support it. So I have those reasons why I am a little hesitant. But then I looked at it, I listened to some other contributions, and I looked at reasons why I should support it. And some of these things are, I've realized that society is crying out for help. People are being victims of crime. And again, if it is even executive failure, I think, we may have a duty in Parliament to see if we could somehow give our population, give our citizens, somehow give them a level of relief. And if I think that we are here in the legislative trying to pick up executive slack, I think I am tempted to help our citizens in a way, because I see the need, I see the suffering, I see when people are out there victims of crime, when the offender comes back out into that community and they are facing that person, it is a difficult thing for those individuals. And I'm faced with people having panic attacks when those offenders are out on bail and they are seeing those persons there. They know they have committed crimes. And those individuals in society have that great distress. So we have to factor that in. And figures we looked at is, it's atrocious, where I think the figures in 2018, there were 988 guns seized, according to information given by the police commissioner. And there's an estimated 9,000 illegal firearms. That was in 2018. But as the Attorney General had mentioned, that this figure may have been mushrooming now, in the sense that with the input of the migrant population. And I'm saying is, if we are looking at forested areas and we are seeing migrant populations coming in there, we're finding a lot of people there. What about the guns that are coming in? Smaller. So guns are coming in. There's no doubt about it. So again, it shows a failure of the executive. And, Madam President, there's a new breed of criminal out there, right? The new breed of criminal will have guns. So, and they are willing to kill, and they have no sort of emotion, no sort of compassion. It's like it's an army of psychopaths going after their own agendas and willing to kill a person. So just as how you'd kill a fly, they without any thoughts about these persons and families. So it's a new breed of narcissistic, sociopathic criminals roaming our country. And we are seeing that element. So I'm thinking we have a duty to see if somehow we can get these individuals. Now, obviously, getting those individuals, it's at that level. They have already reached there. But obviously, we need to get to the root causes of crime. We need to start in the homes and school to recognize these future criminals and put things in place. So yes, but in the interim, I think this bill will help some of the ordinary citizens who are like sitting ducks, waiting for the criminal to rob, shoot them, shoot their relatives. And I think, thank God, our present Commissioner of Police, Mr. Gary Griffith, has a policy. Again, he has opened up a policy of granting FULs that so persons can now be afforded the opportunity to defend themselves, family, and property. So this is one of the reasons why I would support it, the fact that we need to help our citizens. Another reason is I have looked now at the criticism made against the Attorney General that he's bringing in laws that are, draconian. I've been hearing certain persons mention that the Freedom of Information Act is coming up and people are looking at the government in a strange way. Are they bringing in?
Senator Deyalsingh, there is no Freedom of Information bill before the Senate, and there is a rule about anticipation. So I would ask you to desist in any commentary on that.
I'm guided, Madam President. So I'm looking at, is it that we are looking at the Attorney General's bill and having a cause of unnecessary alarm? Is it that we are alarmists? We are saying, hey, this is a draconian bill. it will erode the rights of the citizen. So I was forced to look elsewhere. And I was forced to look and see, did any other countries look at any sort of bail amendments? And what was their reaction? And I looked at Australia. And in Australia, there is the state of Queensland. And in Queensland, they amended the Bail Act to assist victims of domestic violence. So then, we looked at this. And when the Queensland's parliament had to consider this, people also expressed concern about the erosion of rights of the individuals. But they had amended their act, and in 2017, the act received assent. And following its passage, on March the 22nd, 2017, they had a similar situation where people argued that their act would also erode the rights of the individual. So, in their act, there was a reversal of the presumption of bail for an alleged offender charged with a relevant domestic violence offense. So, with this bail reform that they had and they had got passed, it actually was now up to the offender to see why he should not be granted bail and allowed back in the community before they face the court. So Queensland's Parliament passed the bill, the Domestic Violence and Another Act Amendment Bill in 2017, and they reversed the usual legal process where police and the prosecution would have to argue why a person should not be granted bail and kept in custody, and the need to provide more safeguards to domestic violence victims, including provisions for courts to order alleged offenders to be fitted with GPS tracking devices, etc. So what was strange about this bill, it was the opposition leader who introduced the bill in a private member's bill. And there, the entire parliament did support the bill. So I'm seeing a level of support that this Queensland parliament had, that opposition leader has a bill, but it was supported for the good of the population. And this bill came about after there was a public outcry where there was a person called David Bradford who had been released on bail. And after he was released on bail, he went and killed his common-law wife. So it was as a result of the public outcry, both the opposition and the leader of the opposition came together and got this passed. And what was strange, in Queensland, there was only 18 women who died from domestic violence. Only 18, but they were allowed to pass that bill, which took away the rights of the individual. And there were more than 22,000 domestic violence protection orders each year, but 18 die per year. So therefore, Queensland showed me that their parliament was willing to take away the rights of the individual. But not only in Queensland. We found that in New South Wales, their parliament again looked at their bail amendment bill, and they looked at the 2010 bill, and they actually made some changes again. And in 2013, they passed similar legislation that the Queensland legislation had passed. Again, looking at those individuals, taking away the rights. So, Australia, we have examples there. But, Madam President, in New Zealand, in the Parliament of 2013, they reviewed the 2008 law. The bail amendment bill in 2013 require that a person on a murder charge or repeat violence, drugs, or sex charges, just like our bill, would have to persuade a judge that the community would be safe if they were released. So again, they put the burden now on the offender. And they call it the Christie law in New Zealand. So again, most of these pieces of legislation came about because something happened to some individual out there. There was a public outcry, and when you get that, that outcry out there in the community, the legislators there were they decided this is our time now. Let's pass some legislation because the population out there is suffering, the community is suffering. So they call it the Christie's law, and it came about after the murder of a North Shore teenager, Christy Masur, at the hands of a 19-year-old person who was on bail at the time. So was on bail, but came out and did this. So again, this bill would also make it more difficult for young repeat offenders to get bail and allow police to arrest people who repeatedly breach bail without a warrant. So this is the extent that they went. In Canada, their parliament, so I'm looking again, parliament in Canada, there's something called Wynn's Law. And Wynn was a police officer, David Wynn, who was shot and killed by an individual in January 2015 while attempting to arrest a man on warrants. And the person who killed this officer was on bail despite 30 outstanding charges and a lengthy criminal record, and he killed this police officer. So therefore, when the Parliament in Canada looked to review certain pieces of legislation in terms of their bill legislation, they were trying somehow to say that when somebody is applying for bail, they should have their mention all their previous charges. However, the Wynn's Law was officially defeated in the House of Commons in June 2017, but there is still some public outcry out there and whipping up of public support to see if they can get this somehow changed, the Bail Act changed. Liberals said they agreed in principle, but wanted greater changes to the bail system. So with public insistence, if kept on the front burner, this could change. So we look around the world, there are changes. So this is a reason why I may want to support this. Other jurisdictions outside have supported it, have seen the need. Again, why would I want to support it? Because the cost to the victim. I have seen victims of crime coming in with panic attacks when their alleged offender is out on bail. And if you want to calculate the cost of somebody with a panic attack or depressive disorder or having to hide from their homes, miss their jobs, having to come in St. Anne's Hospital to spend a month to get medication, it's a similar cost to keep somebody in the remand yard. If it's 20,000 you're looking at, it's a similar cost when you factor in the doctors, the nurses, the food, the medical care. So a similar cost. So I'm saying for the victim, I would like somehow to say that, we should somehow, look at helping these persons who would have the panic attacks, who would have facing these repeat offenders. Another reason I would like to support it. Okay, so I've given reasons why I may not support it, because of the police may have the capability of framing individuals. But this piece of legislation, as mentioned by the Minister of National Security, police have been asking for this piece of legislation for a long while, because the police officers realize they work hard, they may catch somebody, they may put them away, but then as it goes before a magistrate, even though the police officers may tell the magistrate, hey, we object to this man getting bail. You hire an attorney, you have the right attorney, you know the right legal person, you're out on bail. So what I'm saying is that it makes policing more difficult, because they now will have to go back at these individuals. While if these individuals are away for a space, the police officers will have, to deal with new offenders. They don't have to worry about the old ones. So, they always have to play catch-up. But then, as Senator Vera mentioned, we need safeguards in place. We have to get safeguards. We have to get to the presumption that a police officer mightn't like me, and next minute I have missiles in my water tank. What am I to do? When we have the camera system in the police officers, I'm suggesting that this is something we need to go after. Police coming to arrest me, be it a joint, be it a gun, be it whatever they want to arrest me for, let them be equipped with their cameras so the evidence will be there. So we are putting that as a safeguard to prevent somehow any sort of police framing up anyone. Also, if an officer wants to put a charge on someone, let it also be sanctioned by the superior officer at the station. So I'm thinking we have to put things in place to try and prevent any sort of police misuse or abuse of power. Because you see, certain individuals, when they are that power of being a police officer over someone, their egos may get in place, and they may be quite willing to go after somebody, plant something on them, charge them, and and this is what we have to look at. And it's a similar factor we have, that when individuals hold guns, when a young guy holds a gun, studies show their testosterone level goes up. So they and all will have that sense of power. So again, why should I support this? Being a medical practitioner, there's the World Health Organization, and the World Health Organization stated recently that crime is a public health issue. So I am duty-bound now in my profession because they say the issue of violence can be prevented and its impact reduced in the same way efforts have helped in prevented and reduced pregnancy-related complications, workplace stress, also infectious disease. In the same way, World Health Organization has said we should now look at crime as a public health issue. So being my medical training now, I'm thinking if I can give any sort of support to help in cutting down the violence in society, I'll be doing my duty as a physician also and upholding the goals of the WHO. Again, I looked again. When you look at the system of bail, there's the professional bailers. And we know sometimes things are not too normal in these situations, how people get bail. There are talks about a 10% and a 5% will go to certain persons who own property, deeds, and there's the idea of things may not be right with the professional bailers out there. So I'm thinking, in a sense, this may cut down some level of inappropriate behavior on part of bailers if we could cut down the amount of bail that they have to be granted. So who will lose out from this? Some attorneys. And I'm happy our new senator declared his interest that he is an attorney, and he will also have a bail to give. So he declared his interest. So attorneys may not like it. The professional bailers may not like it. But what I'm saying is that we have to see what can help society. So I looked at the objections of the Law Association, and I heard it. But again, I'm thinking their opinions may be biased. Because in attorneys, my judgment, the attorneys, and they are the ones who may have to go and also apply for bail. It may be money out of their pockets. I hope my other attorneys here don't strike me down for this, but I'm just saying. So the Law Association there, they have given their opinion. I've looked at the recommendation of the Joint Select Committee. I've said government has to look at those recommendations to help this bill. And then, again, to support this, I also noticed that we have to look at, if we are going to support this bill, there will be more prisoners. And even though I mentioned the two cases before in Australia, what is found is after this bill has passed in Australia, and the NSW, after the passage of the bill, they realized, and it was an online article I want to quote, Madam President, where it is prisons, the new building boom in NSW. And it is in government news at Australia, .com Australia. So it tells you that in 2016, that yes, there's an increase in the prison population. There's an increase in persons who are out there in the prison, and they now there's a need to build more prisons. So this is what I'm thinking the Attorney General may have to look at. And even in New Zealand, which passed that legislation, again, we are looking at the fact that they have also recommended that there's a need to build in more prisons. As I am coming to the end, Madam President, I would like to just bring up a matter here that in November 2018, the whole idea of bail came up when I had addressed the mediation board, and we were looking at domestic violence. And the domestic violence, it was recommended that people who and I'm making this contribution because I may want to add on something to this bail, the schedule of offenses. So I had made a recommendation there that with the domestic violence and people killing their partners, they should have, a level of risk assessment, and bail should be denied until, there's a risk assessment to see if these individuals who beat their partners if they're at risk of killing them. And there are risk assessment scales. So, but I was criticized for that because people were saying that this was preventative detention. And it was attempted, that how could I say prevented that they're going to kill? But there are risk assessment scales we could use. And even judges in certain jurisdictions, there are risk assessment they have that they could determine if this person who's going on bail would be somebody who's at risk to the community. So why I quoted this? Because, people will say, saying no bail for a person is draconian. But I would like to quote, again, recently, I'd like to quote from Newsday, Rachel Espinay, Newsday, Thursday, 11th April, 2019, where the esteemed chairman of the Equal Opportunities Commission, Mrs. Lynette Sweet, actually said no bail for them. This is the headline of the article, no bail for them. So if no bail for persons with guns and with serious offenses to the children could be considered in this parliament, she also considered that, no bail for domestic violence perpetrators who break restraining orders. And this was a call made by the Equal Opportunity Commission, President Ms. Lynette Sweet. Now, so here you have an esteemed attorney, chairman, making a call for no bail. And she actually ended her call by saying that we have to review the Bail Act, and which was going to come to Parliament. And commenting on Sweet's statement during a break in the Senate, Attorney General Faris Al-Rawi disclosed, we have a draft of the Bail Act, and again he said here that we are going to look at this domestic violence issue because we have too many women are being killed and murdered. And I think we can use this bill to help those women. And this is what I see, lacking a bit in this, schedule that I'm seeing here. So, as I looked at the Queensland law, in Queensland, when they recommended the changes to their Bail Act, they actually looked at the domestic violence, that if someone is going to strangle somebody, stalking these women, or animal cruelty charges, the Attorney General said those three signs, the strangulation, attempted to strangle somebody, is stalking them, animal cruelty charges, those are dangerous individuals. So once you have that person, if he's applying for bail, should be denied bail. And I'm trying to, ask the Attorney General, just as in Queensland, I looked at Clause 5, and I'm hoping that we can add on in Clause 5 at Part 24, Part 2, and new subsection K, where we look at, any sort of breach of a protection order to high-risk offenders, including those charged with strangulation, stalking, and animal cruelty charges, be also included in this piece of legislation. So in closing, I looked at the bill essentials, and I also want to just comment on Section 7, where Section 7 said that we would have this bill in effect for 5 years. I'm thinking 5 years may be too much, because if we're looking at the parliamentary, the terms, we don't know who will be in power for the next 5 years. So to me, it's unfair and unnecessary burden to saddle another party if they're in power with a 5 years. So I'm saying 5 years, I'm willing to say 2 years, Madam President. And again, I think we need, in conclusion, to provide, to have a right balance between public safety and a defendant's right to be considered innocent until proven. And in closing, I think at this time, a rebalancing of the scales of justice to tip the balance in favor of the victim and the community. Community safety is paramount. We have to stop the wild, wild west culture we have at our nations right now. And, I think 2 years is enough to at least try and give us some sort of tip back into the balance. We will review it in 2 years' time. We need to show those persons out there we are willing to fight them, not with guns, but with legislation. So I presently would give my support to this bill, unless some other future presentation I hear convince me otherwise. Thank you.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam President, for the opportunity to join the debate on this bail amendment bill. Madam President, in my very, very early years, I grew up not too far away from Cecil Hume, the famous Calypsonian maestro. And it wasn't unusual to come in contact with maestro, because I myself was growing up in a town that had Lord Superior and the famous Zandoli. So very, very early on, my two older brothers and my parents ensured that I had my fill of good calypso. And the one I reflect on the most, and as I listen to the four opposition senators who went before me, I thought about Maestro's 1974 classic, Mr. Trinidad. And the most famous line, in fact, most people don't know it by that name. Most people know it by Trinidadians really don't know what they want. And if I have to amend Cecil Hume's classic, I would amend it in this way after listening to my colleagues on the front bench. I would say, and I can't sing, Madam President, but I will say it in this way. In 2013, you like the 120 days. In 2019, you say in your amaze. You say you don't like this bill, but in 2013, you pass the same thing still. So to make a long story short, from in front, the opposition really know what they want. Unfortunately, Madam President, I still have also memories of Independence Day 1977, when the news of Maestro's demise came. He having been killed in an accident the day before. Madam President, why do I say this opposition does not know what they want? We don't have short memories. I listened to this argument. Let me start with Mr. Senator Obika about separation of powers in relation to the removal of the court's discretion to grant bail. Well, Senator Obika was not paying attention. Madam President, it was my friends on the other side in Act number 7 of 2015, because in a previous debate in 2017, I referred to the 12 amendments that the original Bail Act had gone through. And one of those was an amendment in 2015. And that amendment, Madam President, had to deal with the restriction on bail in relation to the anti-gang legislation. And that amendment in 2015, which my friends introduced, had a provision where a court shall not grant bail to a person who is over the age of 18 and charged with an offense under the Anti-Gang Act 2011. So, Madam President, if this bill before us now breaches the separation of powers and interferes with the discretion of the judiciary, then my friends are well schooled in how to do that. And since they did it then, they should be prepared to do it now. But that is not what is happening here. The Constitution is very clear that this access to bail can be interfered with reasonable cause, and that is what Senator Obika also quoted. So all I could say when all I could think when I listened to Senator Obika is that the opposition ain't really know what they want. And Madam President, I listened to all the opposition speakers so far speak with amazement on this 120-day provision, as though the government was doing something that was new, that was virgin territory, that had been conceived by us to interfere with the fundamental rights of these citizens, and of course that would be unsupported by them. But if I have to find justification, Madam President, to support this 120-day provision, I will go to one of my favorite criminal lawyers, Senator Sturge. I have on record congratulated Senator Sturge on many occasions. And I want my friends to go back to the Bail Amendment Bill 2015 and the debate on Tuesday, March 31st, 2015. And that bill dealt with anti-gang, but it dealt with firearms in the same way we are trying to deal with firearms. Because if my friends on the front bench don't understand it, I understand it fully, you know. And I warned Senator Mark on the last occasion when I responded to his motion on the safety of prison officers that this day was about to arise. This day was about to come when the opposition must go on record in full view of the country in relation to their attitude towards firearms and bail. And what we are doing here, Madam President, is trying to bring back in place what this same opposition advocated and was successful in getting done in 2015. And it is Senator Sturge. When Senator Heath talked about what will happen in the 120 days, it is Senator Sturge who provided the justification of the 120 days. But even before that, it was my friend Senator Sturge, with his expertise and experience in the criminal jurisdiction, who was telling us, and I quote, "Criminal does not simply carry a bull pistol or a ruler to lash somebody if they resist. He has a firearm. Firearms kill, so he's a potential murderer. And that is where the rights are being deprived." I can't disagree with Senator Sturge. I cannot. That is the justification. We are dealing here with a potential murderer. And we are trying, Madam President, to prevent that person from being on the street in certain circumstances. And we are doing what was done in the past by my friends, and I see no reason, because I've listened to them. I commend the independent senators who have offered us potential amendments. And I know the Honorable Attorney General will address it. I can't disagree. I can't disagree with what has been proposed. But I listened to my friends, and at no stage did they seek to tweak, to fix, or to improve what is on offer today. What they did, Madam President, so far, is to distance themselves from the concept offered by the government. Distance themselves completely from the concept, one, that in order to deal with the issue of illegal guns on the street and the possibility of guns in the hands of criminals being converted to murders, we should deal with the people who stand behind those firearms. And if someone is found with a firearm, then the access to bail should be restricted. And if there are persons who are on charges, or who a person who is on a charge listed in Part 2, and that person is charged for a second time for a Part 2 offense, they should not have access to bail unless the evidence is not taken in their matter within 120 days. That is the concept. The concept is to link firearms to potential murders and other offenses, to address the pervasiveness of firearms, to address the pervasiveness of criminals, and I make no apology for using the word, and to address it through a process provided by the Constitution, through legislation, that is eminently familiar to the 5 senators sitting on that bench today. And I will accept not a piece of hypocrisy from the opposition bench today. Madam President, it is so ironic that Senator Hussain himself would disagree or go in the opposite direction to Senator Sturge. Because this is what Senator Hussain says to us in his contribution, and I must say, Senator Hussain shocked me, because it was exactly 30 minutes into his contribution, he said, let me refer to the bill. 30 minutes into his contribution, he says to us, let me refer to the bill. He says, I want to get specific. At exactly 11:59 a.m., he says, I want to get specific. Well, I got specific right off. And before he got specific, we had to hear about the detection rate, the ballistics report, the murder rate, the cost of having a prisoner is $15,000 a month. We went through that through several JSCs. It's $15,000. What is the relevance of that? What is the relevance of that to protecting members of the public from people who walk the street with illegal firearms with intent to murder or cause mayhem? What is the relevance of that? And 30 minutes down the road, we got to something specific. But among the specific things was a link that Senator Hussain attempted to make. He condemned the bill on account of the low detection rate. He said, I disagree with this bill because the detection rate is low. But it's funny enough, on March 31st, 2015, Senator Sturge offered the low detection rate as a reason for restrictions on bail. And in his explanation, this is what Senator Sturge offered. He says, a man who is standing in front of you on a gun charge, loaded firearm, that is a man who may quite possibly be a person who has murdered, and he is yet, because of our low detection rate, he is yet to be picked up on a murder charge. So Senator Sturge, as he was then, was saying that because of the low detection rate, a murderer, or somebody who should be questioned in relation to a murder, has not been picked up. And if he shows up somewhere else behind a firearm, there is a likelihood that he may conduct himself in the same way. And restrictive bail will remove him from the streets in the manner the failure to deal with him on the murder charge has not done. And I can't disagree with that. I happily associate myself with my former colleague, Senator Sturge. It makes sense. It makes sense. So, Madam President, I wouldn't tell you about Rowley. I'll tell you about Garvin Nicholas. Madam President, the then Attorney General on Tuesday, March 31st, 2015, Senator Nicholas, as he was then, I cannot disagree. I don't have to go far to explain this 120 days, because it is my friends. They understood that what it means, it meant doing something that we would not ordinarily do. It meant interfering with fundamental rights. And in piloting that amendment bill, Senator Nicholas put it on the Hansard. It's there. I don't want to read it out. Put it there. That we recognize what we're doing here is not something we would ordinarily do. But these are not ordinary circumstances, Madam President. And when you go back through the 12 previous amendments, the amendments which were made to bail legislation from 2005 coming right up to 2017, each amendment reflected what was happening in the country at that time. In 2015, 2005 to 2008, the period of kidnappings. And law enforcement and citizens and people who lived here and observed understood that the restricted bail conditions in relation for the crime of kidnapping, persons arrested in relation to kidnapping, was one factor which went towards the reduction of the pervasiveness of kidnapping. Later on, when we got to the issues of gangs, it is the restrictive bail conditions in relation to anti-gang provisions that, if we had done what we were supposed to do then, would have assisted in dismantling gangs and restricting the growth of the gangs. And Madam President, just like my friends on the other side in 2013, again in 2019, we recognize once again that this issue of firearms, the pervasiveness of firearms, the use of firearms in the commission of offenses, it has not stemmed. Whether it is because we don't have enough cars, whether it's because the air conditioner not cold in the police station, whatever the reason. And the fact is that I've said in this House on many occasions that if we believe and if the data shows us that most offenses are committed with firearms, murders are committed, the majority of murders are committed with handguns, then our legislation to target those who hold those guns illegally and are prepared to discharge it to destroy somebody's life. And more importantly, they should be taken off the streets. And that is what, in response to my friend Senator Mark, in relation to the safety of prison officers, I warned that if you wanted to protect prison officers, and we should be doing that, and if you wanted to protect all the other citizens of this country, then we should be looking at serious restriction on bails, particularly the Part 2 offenses, and particularly, Madam President, the issue of firearms. That is the reality. And Madam President, I listened to my friends talk, and it reminded me of Senator Sobers on one of the occasions when he was here, and he said to us, the government has done nothing on crime. And I listened to my friends, and you know, I listened to Senator Haynes, and the thought that crossed my mind, every time the government brings something, the opposition wants something we did not bring. It's like that fussy ant that everybody have. And you bring the water, it ain't cold enough. You bring it, it's too cold. You bring the tea, it's too warm. Every time. So if you bring something on bail, they want something on DNA. If you bring something on DNA, the opposition want to know about the bracelet that they passed in 2011 and did nothing. And every time we bring something, they want the something that's not here. Well, you know what here tonight? Restrictive bail conditions, and we want to see what you will do. And the country will watch you, because you should have no problem in doing tonight what you did before. I listened to Senator Haynes, for example. I listened to Senator Haynes describe what we're doing here as a level of shamelessness. But what could be more shameless, Madam President, than distancing yourself from a concept and an approach to criminal justice that you introduced? You brought it, the 120 days. And what could be, I don't want to accuse my friends of being shameless at all. But if I have to say anything, I will say I am less shameless than you. I am less shameless than you. Because the cooling off period, that was in reference to the cooling off period. And I listened to Senator Haynes also, Madam President, talk about corralling people to lock them up for 120 days. Madam President, it is, Madam President, I have been around a little while. I had been around a little while, and I saw young men, and Senator Mark got angry with me one day when I used the word black. Young African men, Afro-Trinidadian men, profiled, corralled, pushed into vehicles, Ministry of Works trucks, public utility, Wassa truck, and taken and incarcerated, and something which is costing the state, of course. Is costing the state, of course. But that is my concept of corralling people. But we are not locking up anybody for 100. And the government isn't doing that. The government don't arrest nobody. In fact, none of us in here will have a role, a direct role to play in the implementation of this legislation. I've always said that. We have one thing to do. I have one thing to do tonight, and that is to advocate and participate in the passing of this legislation. That is my role. And what happens to it out there, unfortunately, falls to a different group of people over whom we have some oversight when we wear different hats within the parliament. But, Madam President, we have to create the law. We have to create the law. And we are not directly quarreling anybody or interfering with anybody or going and grabbing anybody. And if the police act in a capricious manner, if the police breach fundamental rights, if the police do what they're not supposed to do, then there are institutions set up to deal with that. It is not for me tonight in the Senate to worry about how the police will manage this piece of legislation. But my job here tonight is to give this country and to give this tool to the judiciary and to give this tool to law enforcement in this country. And I am quite happy to do that. Madam President, I listened to Senator Obika again talk about trampling. Yes, I listened, he's my friend. Trampling on the rights, interfering with fundamental rights, and so on. And again, I say, this is not the government acting vai-ki-vai. This is the government doing what it is entitled to do, bringing the legislation and looking for the support of the legislators in this House. But, Madam President, I should have known how my friends on the other side operate. I should have known, but I always give them a chance to surprise me, because I remembered having followed the 2015 debate with my friend, then Senator Sturge, having followed the debate and been extremely impressed with his defense of the 120 days provision and the other things relating to the restriction on bail. I was very impressed with his contribution, Madam President. I listened also to when he spoke on his own motion, private motion, to deal with the unacceptable levels of violent crime in the country, and in particular, his contribution on the 14th of February 2017. And that is when Senator Sturge, as he was then, referred to and attacked the PNM's 10-point crime plan. And towards the end of his contribution, Senator Sturge, and I still thank him for it, offered short-term, medium-term, and long-term solutions to this scourge of crime, as he described it. I immediately, when I responded, distanced myself from his first short-term suggestion. I could share it with you: fire all 3 ministers of national security. I distanced myself from that. But, Madam President, throughout the recommendation, short, medium, and long, Senator Sturge never managed to mention the word bail. So 2015, a strong advocate, on behalf of my friends on that side, strong advocate of bail. They passed bail amendment in 2010. They passed bail amendment in 2013. And they passed bail amendment in 2015. On one of those occasions, Madam President, they made a clean sweep. On one of those occasions, Act number 11 of 2011, in relation to restrictive bail provisions for gang members or suspected gang members, they had no votes against in the House and no votes against in the Senate. A clean sweep, Senator Mark. You were down there, you would know. A clean sweep. Everybody supported them. And then the same opposition Senator Sturge came in 2017 and offered a plethora of ideas, short, medium, and long, and never mentioned the word bail, distancing himself, as you're doing today, from the idea, the concept that you introduced, that restrictive bail conditions used properly could impact on crime. And what crime are we talking about? Most importantly, we talk about everything that is listed in Part 2 of the bill. But most importantly, as I warned Senator Mark a few days ago, this piece of legislation targets in the main firearms. And if you do not support, I have no problem in those who have offered amendments. The government, and in particular the Attorney General, has already indicated it is receptive to the amendments. But if, Madam President, for the sake of making the government look bad, distancing yourself from what you stood for 2010, 2013, 2015, if you feel, my friends on that side feel, that tonight is the night to punish the government for doing what is right, then the public in this country will not allow them to escape with their own hypocrisy. I thank you very much.
Madam President, thank you very much for allowing me to intervene at this time of the evening. No, I'll be very calm. Madam President, as you know, I'm a very calm chap. Madam President, I would like to say from the very outset that the bill that we are dealing with today, an act to amend the Bail Act, Chapter 460 of 20, well, let me just put it properly, Madam President. The Bail Amendment Bill of 2019, that is what we are dealing with here this evening. Madam President, I want to say from the outset that confession is good for the soul. And I think that what we have been witnessing this evening on the government bench is a clear confession and, by extension, admission of their colossal failure to address the fundamental rights of the citizens, particularly under Section 4A1, the right to life, liberty, and to the enjoyment of property. The government has failed miserably. But before getting into the meat of my contribution, I would like to just make some responses to earlier statements made by my colleagues. Madam President, I was a bit alarmed when the Minister of National Security, in his maybe innocence, I should say, or exuberance, stated that there will be more people charged under the Anti-Gang Act by the end of 2019. And he gave us, as a Senate, the guarantee that there'll be more persons or people charged or being charged. And I was wondering, Madam President, I do not know if that was a slip, Freudian slip, but I don't understand how a minister can come to a parliament and predict that many more persons will be charged by the end of this year. And he went on further, as I said, Madam President, to guarantee that to this honorable Senate. So maybe, Madam President, he knows something that you and I don't know. And I think that we should call on the Minister of National Security to explain to the citizenry of this nation what did he mean when he said that by the end of this year, more persons will be charged under the anti-gang law. That's the first area I found very interesting. Madam President, I also want to say from the outset as well that the minister also shared with us that there is no right, or I should say constitutional right, to bail. And we agree, Madam President, but what we do know under our Constitution is that there is a constitutional right to apply for bail. Madam President, there's a constitutional right to apply for bail. But what the government is seeking to do this evening is to pass legislation that will remove from the judiciary, the courts of TNT, our magistrates and judges, that right that is inherent and entrenched in the Constitution as it relates to their discretion to grant bail. And, Madam President, insert that right, more or less, onto the shoulders of the executive arm or organ of the state. Because, Madam President, you would know that in our Constitution, entrenched in our Constitution, there are three principal organs of government, and they are separate, and there should be no trespassing by one upon the other. And therefore, if the judiciary is charged under our Constitution to deal with matters of the nature that I have outlined, then what the legislation is attempting to do is to remove that discretion exercised by magistrates and judges to grant bail. Madam President, I also would like to indicate that my colleague, Senator Deyalsingh, made mention of the experiences of Australia and New Zealand as it relates to legislation dealing with bail and what they did. I just want to indicate to my honorable friend that Trinidad and Tobago is a bit unique. We have what is called an entrenched Bill of Rights. Australia, unfortunately, does not have in its constitution an entrenched Bill of Rights. I also want to let my friend know that New Zealand does not have an entrenched Bill of Rights. They have a Bill of Rights, Madam President, via statute. But unlike Trinidad and Tobago, ours is entrenched, Madam President. So I think it's very important for us to understand the difference between those countries and ours, Madam President. Madam President, I listened very carefully to my honorable friend and Senator, the Honorable Minister of Agriculture, and he made certain interventions as it relates to this piece of legislation. Madam President, whenever we are debating legislation of the nature that we are debating this evening, we have to look at the context. We have to look at the environment in which this matter is being addressed. And Madam President, you and I would know that we live in a very challenging environment today. And it is incumbent upon the legislature, the parliament, which is the bulwark of our democracy, to ensure that whatever we do, we seek at all times to balance the rights of and the liberties of the citizenry against that of the state. And you know, Madam President, there's always an attempt by the executive arm or organ of the state to accrete onto itself more and more and more power. We in the legislature have the responsibility to exercise checks and balances to ensure, Madam President, that there are we do not engage in what I call excesses as it relates to power that is going to be placed into the hands of the executive organ of the state. And that is why when we look at some of the provisions in the legislation, Madam President, you realize that innocent citizens can become easy targets of an oppressive, repressive, malicious, let's say, state. And Madam President, the agencies of state, as you would know, one of them is the police. And whilst we have very great and good police officers, and they work extremely hard, I read with alarm in the last month several judgments coming out of the High Court in which the judges are calling for the executive to amend the legislation dealing with damages, and where the state has to be called upon to honor those damages to persons who have taken up matters at the level of the courts, and they have won. And you know, Madam President, it is you, it is me, it is the taxpayers who are called upon to pay damages and compensation to officers, to victims who have been maliciously prosecuted by police officers. And what the courts of our country have been saying is that the time has come for police officers who engage in malicious prosecution for them to be directly responsible, culpable, and let them pay, and not taxpayers. And the courts are saying to the executive arm of the state, please consider that, because there's too much money that is going down the drain, and they are not being held accountable or culpable. So that is an area, Madam President, we have to take into account when we are dealing with legislation of this nature. Madam President, I am not going to repeat, because you will stop me. I am not going to allow myself to become repetitive. What I would say, Madam President, is that we are very conscious of what would take place and what takes place in this country on a daily basis involving innocent citizens in our land. Madam President?
I'll save you the chance of not repeating. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the contribution of the last speaker prior to the Attorney General's wrap-up.
Honourable Senators, the question is that the Senate continue to sit until the completion of the presentation of the last speaker prior to the Attorney General wrapping up. Those in favour say aye. Aye. Those against say no. The Senate will continue to sit until the completion of the presentation of the last speaker prior to the winding up of the Attorney General. Senator Mark.
Thank you. Madam President, I want to join my honorable colleague because like him, you know, we think alike. He did extensive research. I too did my research. And I want to share with you and this honorable House, because this is how he said earlier on, he was in total agreement with Senator Wayne Sturgis' interventions. I want to share with this honorable House statements and contributions by very honorable members of the Parliament of the Republic that dealt with the same question of bail. And bail, Madam President, as my colleague said, came in 2010, 11, came in 2013, and it also came in 2015. Madam President, I have the contribution here of, at that time, one Mr. Colm Inbert, Diego Martin Northeast at that time. It is dated, the Hansard record, the 12th of June, 2013. And we are dealing with the Bail Amendment Bill of 2013. And I don't want to bore you. I will let my colleagues go to the record and let them rifle through the pages of the Hansard so that you can get more details. But I will just share a few sentences with you, Madam President, so that we can understand the consistency that we have had on this matter, coming from the government when they were in opposition. Madam President, I quote, this is on page 33 of the Hansard, Colm Inbert. And in most situations in England, it is the judge or the magistrate that decides whether you should be granted bail or not. Throughout the Eastern Caribbean, that is how it is. In most of the world, that is how it is. The right to bail, Madam President, is left to the competence of the judiciary. He went on to say, he said at that time, Mr. Speaker, I guess you were speaking to me. I cannot support legislation like this. I want to repeat this. This is in 2013. The government at that time had brought a bail amendment bill and seeking the support of the opposition at that time. This is what Colm Inbert is on record as saying, Mr. Speaker, I cannot support legislation like that. He goes on, Madam President, that is so disproportionate that it has declared the judiciary of TNT to be incompetent to determine matters of bail. And I just close with a sentence, Madam President. The government has provided no justification for this. They have not told us what the objectives are, and we are not supporting this legislation. And so said, so done, Madam President. Not a single member of the PNM in 2013 supported this piece of legislation that was brought. Madam President, I want to share with my colleague because I'm supporting my colleague here, right, like you. Madam President, I share and I join and associate with the views expressed by the then Colm Inbert, member for Diego Martin Northeast. Yes, Madam President, I will not bore you nor this honorable House. I am just quoting a few sentences and I am dropping the case. I'll leave it to my colleagues and to the country to go and get the record. Madam President, the Honorable Dr. Heath Rowley, he is the member of Diego Martin West, then now Honorable Prime Minister. This is on the 10th of January 2014 on the Bail Amendment Bill. I will just go to the last few sentences of his contribution. I quote, so today I am saying to the government, do not waste your time. We are not supporting this. I am asking you Why have you not brought all the measures we thought we had agreement on and come to this House? And to use the cabinet and other matters to deal with matters that you could deal with, right? You're coming here trying to browbeat us. We will not be bullied into passing bad law. We will not be bullied into passing bad law. So, Madam President, as the leader of the opposition then, he did not support the bill. Yes, I am going on, Madam President. I also have the contribution of the then member Marlene MacDonald. And Madam President, it is the same refrain. I do not want to bore you. It's just one sentence. I wait on the response from the AG to state that this bench cannot support this amendment. Marlene was the chief whip at that time, not supporting the amendments. That's a third person. Madam President, like Alice in Wonderland, it becomes curiouser and curiouser because I cannot leave out the Senate. You know, I'm a veteran here. I'm a veteran in the Senate. So I must come to my house, which is the Senate. Madam President, I come to my house, and then who do I see? I see the distinguished Attorney General, who is here in flesh and blood. And Madam President, he made it very clear in this piece of, it is his contribution. And may I share with you the date? The 21st of January, 2014. And I am just quoting a few sentences here, Madam President, so that you can get an understanding of what went on here. Madam President, the fact is that the bill itself provides a remedy. What we must ask ourselves is, are we satisfied as legislators this evening or this afternoon that we are making a reasonable and proportionate intrusion in the balancing act that we are doing right now between the state's general guarantee of certain liberties and freedoms to us all versus the accused's rights to the presumption of innocence, fair trial? And he went on to talk about, are we making a proportionate decision? Madam President, he said the bill itself, we are saying in this amendment that we do not think that the current legislation can meet the demands of what we as a society wants. This is the case of the government, but the act itself requires a judicial officer, someone trained in impartiality as recognized and advocated by then Senator Razia Ahmed when she sat in Parliament many years ago. So, Madam President, the Attorney General at that time, Senator Faris Al-Rawi, made it very clear that he was in support of the judiciary having that impartial and independent role in determining bail and not taking measures to remove that important responsibility. And Madam President, I will not bore you any further. All I can tell you is that when we looked at Camille Robinson-Regis, it was the same. So when we hear from my honorable friend today, that, no, I'm talking about 2013, and I'm showing the honorable senator, I mean, explain to the honorable senator that at that time, the opposition did not lend any support whatsoever to the bail amendment bill. They all voted against it in the House of Representatives, and they voted against it in the Senate. So, Madam President, we in the United National Congress have made it very clear that as the government that will be taking control of this legislature and the other place in a short while, through free and fair elections, we will become the new government. I give you that assurance. Madam President, what we are saying is that when we look at this situation very carefully that is before us, we are seeing where the government, through this piece of legislation, is seeking to undermine a very important principle in our Constitution. And Madam President, you will know under our Constitution, every individual who is charged with an offense is assumed innocent until proven guilty. And what we have in the bill that we are debating today is a situation where the government is seeking, through this legislation, to reverse that particular principle. So, Madam President, you are not yet convicted. You are simply charged. And by being charged, Madam President, you are being told that you are guilty without being convicted. And therefore, in those circumstances, the government is asking the opposition to agree with a measure that could involve innocent citizens being, Madam President, incarcerated for 120 days and even more on the presumption that they say you are guilty. And on what basis, Madam President? On the police charging you for a particular offense. Madam President, I don't have to tell you that when you look at the legislation, you look at Section 5 of the legislation, and you will see, Madam President, where the provision is very clear, where in subsection 3 of Section 5, Madam President, it is pellucidly clear, as the former Prime Minister would tell us, that the court shall not, Madam President, it didn't say may not, They said the court shall not grant bail to a person who on or after the commencement of this act is charged with an offense. So, Madam President, all you are telling us here this evening is that an individual simply has to be charged, Madam President. And once you are charged in accordance with the schedule, which is listed in Part 2, you are just charged under Part 2 of the first schedule that is in this bill, Madam President. Once you are charged, Madam President, you can find yourself innocently behind bars. Madam President, we have a duty and a responsibility to avoid any abuse or any perceived abuse by the executive arm of the state against innocent and defenseless citizens of our country. And that is why our role is so vital and crucial. And the government is so bold. They have come here with even a 5-year sunset clause. You know, Madam President, the government did not even say for consideration, we will have a 6-month trial or a 12-month trial. They want a 5-year trial so citizens can give to the executive of this country a carte blanche power to do whatever it wants and whatever it will. Madam President, how can we, in a society that has respect for freedom and democracy and human rights, how can we associate ourselves with such draconian and dangerous measures? We can't, Madam President. Madam President, the state, if the state, via the government, in this instance the government, cannot provide protection for life, property, and longevity for our society, along with security and safety, then what the government should do, Madam President, is what any decent government should do. I think they should pack up, they should call the elections and let the people decide. But we cannot sit down, Madam President, with a few months to go before local elections and a few more months to go before general election to give to a very, a government, Madam President, I don't want to run afoul of the standing orders, but you know the government cannot be trusted, Madam President. You know, you can't trust the government. You look at some of the actions that the government has been taking over the last 3.5 years into 4 years. How can we now give to the government this kind of power? We can't do that, Madam President. And, Madam President, in Trinidad and Tobago today, the amount of legislation we have on our books, is this bail amendment bill that the government has come with, is it necessary? Can the government not, Madam President, can the government not look at other enforcing, Madam President, other laws that are on our statute books? Madam President, you know, in the United Kingdom, there's something called anti-social behavior orders. I think they borrowed that from Giuliani when he was the mayor of New York. They went at the small problems, the small demeanors, the small crimes, and then they were able to snap up the big crimes. And that is where I believe the government should be seeking to move. Because, Madam President, if we know crime is the major problem in our country, if we know firearms are coming in this country, willy-nilly, we know our borders are open, Madam President. Why does the government over the last 4 years have not taken measures to close our borders so that, for instance, Madam President, the invasion of...
Senator Mark.
Yes.
I now have to just give you a little guidance that you are now going into tedious repetition, okay?
Yeah, so, Madam President, what we are saying this evening is that when we look at our situation in Trinidad and Tobago today, we cannot associate ourselves with the reality of crowding or further crowding our prison environment. Because as you know, this matter of bail, Madam President, when you do not grant people bail, Madam President, it is not only they go to the judiciary and the judiciary have to effect what is in this law, but when they are not granted bail, they have to be sent, Madam President, to jail. They have to be put on remand yard or put into remand yard. But, Madam President, when we look at the state of play in our country, can we rest with some degree of assurance that we have the capacity and the ability to house this excess amount of persons who will now have to be incarcerated? Madam President, that is an area I don't think the government has given serious consideration to. We believe that there is need for the government to look at this whole question on a more organized basis. Meaning, Madam President, we not only have to fix our judiciary, but we also have to fix our prison system at the same time to ensure, Madam President, that these matters are in fact addressed in a proper way. Madam President, we know that the granting or the holding of bail has been a matter, as I said, for the court. But, Madam President, when we talk about bail, the bail amendment bill, when we talk about bail, you only grant bail not as a punishment, Madam President. You grant bail to ensure that the accused or the person who is the defendant is able to appear before the courts of Trinidad and Tobago. And one gets the impression, Madam President, in looking at this piece of legislation and looking at and listening carefully to the Attorney General, that what is being advanced here this evening is that we seem to be interpreting bail from a punitive perspective. We seem to be looking at bail as a form of punishment. And I want to indicate, Madam President, that there's need for us, that there's need for this Honorable Senate not to look at bail from that perspective. We have been tampering with our Constitution since 1994, and we are now in 2019. We have had exhortations from the Law Association as it relates to this question of bail and having the executive arm of the state determine bail for our citizenry.
Senator Mark, you have 5 more minutes.
And Madam President, we would like to suggest to the Honorable Attorney General that a matter like this should require some degree of consultation. I do not know which organizations the Attorney General has been in consultation with on a matter like this. When we are dealing with the rights and freedoms of our citizens, Madam President, there is need to have consultation on a matter as important as this. So,
Mark, I know you have a few minutes, but consultation has been raised by so many of the speakers before you. So just use your last few minutes wisely, please.
So can I ask, through you, Madam President, for the Attorney General to inform us in his winding up which organizations were involved in consultation on this matter? And I would stop on that particular point. But, Madam President, we have seen in the last few weeks in our country where this government has been taking measures and taking action against innocent citizens in our country. We have seen, for instance, the invasion of people's homes by the state-by-state agencies.
Senator Mark, that's really, you can't present a statement like that, okay? So you have a few more minutes.
Well, in other words, Madam President, we have seen, for instance, citizens' privacy and the whole question about freedom of expression and freedom of thought. For instance, the whole invasion, Madam President, as you recall, of Radio Jagrati. That is a public situation in our country.
Senator Mark, no, I really will caution you, please, in your last few minutes, to not impute improper motives. Say what you have to say. You may have to say whatever you have to say differently. Please, don't impute improper motives.
So, well, I'm not imputing improper motives, but I am guided by you. All I'm saying, Madam President, is that the government has embarked on a course of action that has the citizenry extremely uncomfortable. And in those circumstances, we are saying that we have seen signs, we have seen measures and steps being taken by the government against defenseless and voiceless and powerless and ordinary citizens of our country. And, Madam President, you need to have an institution and an organization that can beat back this aggression. And I can tell you here this evening, before I wind up, Madam President, before I close off, Madam President, that the only institution that stands between the PNM and the establishment of a full-fledged dictatorship in our country is the United National Congress. We are the ones that are defending the rights of the citizens. We shall continue to defend the rights of the citizens. In those circumstances, Madam President, we want to tell this government, do not bring repressive laws, do not bring laws to remove the rights of people, do not bring laws and so on to whittle the rights of our citizens. We will not be associated with those laws, and therefore we serve notice on the government today. They will pass it in this House because they have the majority. They will get the majority. But, Madam President, I give you the assurance the government of Trinidad and Tobago will not be able to convince us in the United Nations Congress and the 350,000 people that we represent that this is good law. So they brought it here, they will get it through, but they have to go somewhere else. And when they go somewhere else, then we will talk a different language. I thank you very much.
Attorney General.
Madam President, I propose to do the majority of my wind-up tomorrow, but I'm only proposing to address one point tonight, and that's to deal with Senator Mark. Madam President, the rationale for taking the time to consider recommendations made by honorable senators on the independent bench include the need to do a little bit of homework on the recommendations coming from Senator John Heath, Senator Hazel Thompson-Nye, Senator Vera, Senator Choate in particular as they relate to matters of law. Because I think that there is possibility for us to craft a little bit differently to find some measure. Senator Mark, however, in his most astounding, outrageous, intellectually outrageous propositions, comes to us and cherry picks. And I'm only going to deal with one point. Senator Mark came here to treat with Act number 1 of 2014 and referred to a debate in the House of Representatives and in the Senate, and went through including parts of my own submission then as a senator sitting on the opposition bench, saying that we had not supported that particular law, and he was right. But Senator Mark did not say why we didn't support that law in the full context. And the honorable senator clean skipped over the fact that the law which is closest in measure to the one that we bring today is in fact Act number 7 of 2015. And that particular piece of law, for the record, on a division in the House of Representatives, 36 said aye, no abstentions or objections. In the Senate, the division was 37 saying yes, 3 saying no, and the noes were Helen Drayton, independent senator, Elton Prescott, independent senator, and Dr. A. Edwards, independent senator. And so Senator Mark does not have the intellectual disposition to tell us the truth tonight in the way that he ought. Madam Speaker, Madam President.
Just a minute. Thank you very much, Mr. AG. Madam President, I beg to move that the Senate do now adjourn to Wednesday, June 11, 2019. That's tomorrow at 2:30 p.m. The 12th, yeah, sorry. 11th, yes. Yeah, Wednesday, June the 12th, 2019 at 2:30 p.m. In that sitting, we will bring to its conclusion this bill amendment bill, and hopefully we will conclude the miscellaneous provisions bill.
Financial institutions.
Well, yes. Miscellaneous provisions, financial institution, security and insurance bill, same thing.
Honourable Senators, the question is that the Senate do now adjourn to Wednesday, June the 12th, 2019 at 2:30 p.m. Those in favour say aye.
Aye.
Those against say no. The ayes have it. This Senate now stands adjourned to Wednesday, June the 12th, 2019 at 2:30 p.m.